pacientu drošību un organizācijas pētījumiem. Good morning, everybody. We will have to start our session on patient safety and organizational research. I will be chairing this session together with distinguished Professor Tingle from United Kingdom, from Nottingham University, and he will present after a while his introductory lecture. And what I just want to say is that yes, we see that this room is not full of audience yet, and it is quite typical for a situation when clinicians and doctors have to choose between priorities to go and to be interested in clinical innovations or in organizational innovations. And this somehow shows probably the biggest challenge which we face in patient safety initiatives, in organizational changes initiatives, how to involve real physicians, real clinicians in our problems, so that problems should not be dealt only by managers or by lawyers. So let's talk about it and talk about those biggest challenges in patient safety issues today. So I will give a floor to my co-chair, so Professor Tingle.
Thank you. It's our great pleasure to be here and to be invited to talk to your universities about patient safety. Certainly in England, when I start my presentation, we've been working on these issues since the year 2000. And we have a Rolls-Royce system, but sadly it's a Rolls-Royce with a damaged engine, and it's not getting very far. Certainly we can look at what we do and what you do, but the issues I'm going to talk about not only apply in this country, in my country, in Europe, but they're global issues. They apply in Africa. Last week, I went from plus 32 in Nigeria when I got off the Ryanair plane to minus 15. Doesn't matter, because the issues I was dealing with in Nigeria last week and in Kenya and Uganda are very applicable across the world. The issues that we're talking about today are global issues, because we're all human beings. That's the great commonality. What I'll do is begin my presentation, which I've got some PowerPoints which I'll leave with you, and that will be followed by my colleague. I'm Associate Professor at Nottingham Trent University. There are two universities in Nottingham, and we're the law school with over 3,000 students, and we're a big university. We got the Modern University of the Year award this year. So I'll begin my presentation, and then I'll introduce you to my academic colleague, Clayton. So the title of the presentation is Patient Safety and the Law, and I was presenting this last week. What is patient safety? That's a key issue. Also, the statistics. 1 in 10 patients in the developed world will suffer an adverse outcome, and that's on WHO European figures. Escalating costs. In the United Kingdom, we owe £65 billion for clinical negligence claims. 65 billion. We pay each year £1 billion, and at least 30 or 40% of that goes to claimant lawyers. So a lot of the costs of error are being borne by the state, and they're going to people like me to help pay mortgages and holidays and things like that. Is it right? Yes, I'm a lawyer. I've been training. I do the best for my client. The client's been injured. In English law, the patient is entitled to be put in the position they would have been in had the negligence not occurred. You have a midwife who has not spotted a baby in distress. The baby's born with cerebral palsy. We're looking at about £10 million compensation for that baby. That baby will need 24-hour care, nursing care for the rest of its life. Its life expectancy may be 70 years. So clearly, the issue of compensation is really important. We've got a socialised healthcare structure in England, in the NHS, care free at the point of delivery, but clearly spending over £1 billion a year on negligence is eating into our healthcare services. Patient safety is still the #1 concern of the English regulatory body called the Care Quality Commission. But these problems are not unique. We're looking at different countries across the world, developing, and they suffer the same problems. The concept of reverse innovation is important. When we're looking at patient safety, we can look at our tools, what happens in Latvia. You can share those with Ghana. Ghana may be able to take what you do in Latvia as a tool and operate it with half of the staff that you use because of the ways of doing it. Therefore, Latvia can learn from the export of Latvian patient safety tools in other countries. And the leading body that organises all this, in terms of the policy, is the World Health Organization in Geneva. And they have a patient safety unit, and they also have a global patient safety curriculum that countries such as Thailand and Malaysia and lots of other countries are actually using that. I was last week delivering a lecture to 1,500 students. They were all dressed in black, and they had white shirts and ties and skirts. They were Nigerian lawyers. And these were law students who graduated from English law schools, and they were back in Nigeria at the Nigerian law school in Lagos becoming lawyers. And, as it is, I gave a half-hour lecture on the areas of law that apply to them. And clearly in Nigeria, high levels of surgical complications, overcrowding health facilities, contaminated urethral catheters, poor hand hygiene, lack of infection control. People stay longer in the hospital, financial cost, poor surveillance. So, as an English civil lawyer, I have similar issues in Nigeria, in the UK. There's similar issues, perhaps not as bad, in other countries. So patient safety is a global issue, and lawyers can make a real difference across the world in various countries by looking at the causes of error and how we can increase error. So Nigeria, really interesting country, and there's academic papers on this. The Pan-African Medical Journal. We've a chapter in our forthcoming book on Latvian patient safety law, and also we've got a chapter on patient safety law in Nigeria. Poor knowledge of medical ethics amongst doctors. Gosh, that's an indictment in terms of Nigeria and the medical profession. Prescription errors are also not uncommon. So we've looked at a field of literature. We've identified that it's an issue. I'm an English lawyer, and what we are doing is working on this book on global patient safety law, policy and practice with a chapter written by one of the speakers today in Latvia and also in Nigeria, and my colleague, co-editor, Clayton has done a chapter in the book as well. So what we are looking at is global patient safety. As a lawyer, we need to think about the lawyer's role in patient safety. And certainly in England, there's no joined-up policy really about how law relates to patient safety. The role of claimant lawyers who act for patients is under discussion. The government are thinking, well, let's stop the lawyers getting so much money, so they're putting caps on lawyers' fees. We're looking at the role of fault when it comes to how babies are cared for, and babies who've got cerebral palsy. Can we have a fast-track maternity scheme that deals with these cases very quickly and doesn't have a fault base? Nottingham, similar typical case, admitted liability for a baby's death after doctors made a 2-inch deep cut into his scalpel and skull during a C-section, causing him to hemorrhage. His mother spent the past 4 years demanding answers, undergone a gynecological procedure in October known to cause complications, not advised of risk, and the case was settled. High-risk pregnancy, several missed opportunities to elicit a full medical history or even check her medical records. And had staff been aware of her medical history, a consultant would have performed the caesarean section rather than a registrar. So that's not an uncommon case. It doesn't happen every day, but that's one of the cases that will next year form part of the £1 billion that we pay on clinical negligence. So every year, an estimated 1 million patients die in hospitals across the world because of avoidable clinical mistakes. Potentially 150 avoidable patient deaths per week in England. 1 every 35 seconds. On average, 1 incident of patient harm is reported every 35 seconds. A Johns Hopkins study in the States says that medical error costs 250,000 lives every year. In the US, it's the biggest killer after cancer and heart disease. And we've had a number of crises in the UK. One was the Mid-Staffordshire crisis, which left 1,200 patients dead at a hospital over a period of time. And that's a disputed estimate. Wards and toilet facilities left in a filthy condition, privacy and dignity, even in death, were denied. Triage in A&E undertaken by untrained staff. Staff treated patients and those close to them with what appeared to be callous indifference. This is a few years ago. The government responded really well and brought in new concepts. Intelligent transparency. What's that? But in 2017, the Care Quality Commission said, worryingly, safe priorities and quality improvement are not always audited properly. Poor infection control. Well, we saw that in Nigeria. Issues around inadequate checking of maintenance equipment or environment. Insufficient record keeping. Not sharing information. So safety is still a concern. And we've got new products to try and reduce the costs. But the leading problem, and I'll finish in a second, is that the government have not really conceptually thought about the issues in a deep academic way. They've had a policy which is reactive. They've developed policy in silos. They've had real difficulties in developing an ingrained patient safety culture. So how do we go forward? They owe £65 billion. They paid £1.1 billion to patients. Over a third of what they spend each year is received by the legal profession. So, where do we go? And the government have recently said, well, yeah, About 4% of patients who can sue do sue, but there'd be certainly more patients. So that's what I wanted to say in terms of where we are in the UK in terms of litigation. We're one of the world leaders in patient safety along with the US. We haven't got it right. We've been really good at having a go. The way forward, to think more deeply about what we're trying to do and to have some conceptual underpinning of what we're trying to do. Don't just create an agency. Think about what the agency is going to do and how it's going to relate to other agencies. When you have a tool, think about what that tool is going to do. Don't develop your policy top down. Try and develop it bottom up. And then arguably, don't let the state take responsibility totally for developing a safe system of care and a reflective care environment. I would argue that doctors and everybody who works in the hospital clearly have a professional duty to do this. It's part of being a professional. It's taking care, it's being reflective. Economics, saying you don't have time is not really good enough. So we should be saying to everybody that everybody is a patient safety advocate. And really one of the fundamental issues is how across the world, in Nigeria, in lots of other countries, we develop a culture which puts the patient first. It's easier said than done. It's really easy to say we want an ingrained patient safety culture which is patient-centric. The patient is the most important person in the care equation. Easy said, very difficult to do. Thank you.
Thank you. We have time for some questions right now to Professor Dingle.
Any questions? Our book will be out soon, so we can let you know about that. But certainly in English universities and in universities across Europe, medical law is probably the most popular undergraduate law option on our law degree. And certainly in public health, we've got some students who are master's students in public health. Patient safety is a real interesting topic. So it's becoming part of the curriculum. It's a mixture of law and it's a mixture of ethics. But when I talk to lawyers in the UK, this is an area that they can make a real difference in, and doctors, because every country in the world has the same sort of problems. And you can make a real difference by working for international organizations such as the UN, or even doing internships as students in international organizations. In April, I'm going to Uganda, and I'll spend a few days working with a patient safety group there who take interns from Germany. They spend 2 to 3 months there. The girls and the guys rent a house, and it's really good work. So one of the important things in your studies is, if you're studying law or medicine, if you can do an internship in some international organization, that's really, really helpful. And I think it does broaden your perspectives. This is what I'm telling my students, that, and 2 have done it, and they benefited from it. You can make a real difference across the world, in Africa and in other countries like that, by just looking at some of the concepts that you're working on in Latvia, and if they work, you can be an advisor and do an internship and make a real difference.
Okay, thank you. Okay.
My question is about negligence. What is the definition of the term from from law perspective, and is there a difference between human error and negligence, or is it the same?
Yeah. In English law, and in the law affecting everywhere where England's been, the definition of of clinical negligence is basically when an individual, a doctor or a nurse, fails to use what we call reasonable care. And we look at that objectively. So if we're looking at an error which a doctor has made, say an A&E doctor, what we say is, what would an ordinary skilled doctor in that position have done in that case? So we get expert evidence to say, what is the standard of care expected? And then we say, now we've got a standard, has that person who we're accusing of negligence reached that standard or not? So we have a line in the sand which is established by the experts. They're not saying what they'd have done because they're experts, but what they've expected the junior doctor to do in that situation, objectively, and then whether this doctor had fallen below that standard, which the experts say is an appropriate standard. And if they've fallen below that, they're negligent. And that negligence has to make a difference. We have a test called the but-for test. And if it's not made a difference, if it's not materially contributed to the damage that the patient suffered, then there's no negligence. Even though there was, it may not have made a difference. So if it makes a difference, if it's made an effect that's more than negligible, then you prove the breach of duty and you prove negligence. Now sometimes things just happen because they're a risk of treatment, and those won't be regarded as negligent. But sometimes there's an untoward incident which harms the patient. It may not be legally negligent, but it's certainly caused adverse harm, and it's something that could occur within that balance of probabilities. But actually, a lot of the things that we talk about in patient safety could actually be brought in our civil courts. We talk about medical culpability. What we're talking about here is the doctor being sued, or rather his employer being sued, the hospital, because most doctors in hospitals are employed by the hospital. So under principles of vicarious liability, we would sue the hospital, and we'd sue them in civil law. Criminal law is not involved unless they've been almost criminal in culpability, which means that they've gone for a glass of milk while the patient is on the operating theatre, or turned the alarm off, or missed something so obvious that anybody would see it. So we're talking about civil law, and they may also be not allowed to practice if it's so gross. But in English law, we can have a situation where the hospital pays for the negligence, but they say we're paying on the basis of not admitting liability. So they pay, nobody has been found negligent, but if it went to court, there's a risk they may. And actually, only about 50 cases a year in the NHS go to court, about 3% of cases. Most cases are settled before they go to court. So there's a difference in terms of negligence and just things that happen. But also there's the in-between, that there are things that happen which shouldn't happen and which can be easily avoided.
Okay, thank you, Professor. And so we have to move forward, and as the next speaker will be Agnes Bankava, and the role of the treatment risk fund in the patient safety culture. So it's a Latvian case, and how we deal with problems in with treatment risk fund.
Hello, my name is Agnes Bankava. I'm a lawyer, and I will introduce you about the role of the treatment risk fund in patient safety culture. The treatment risk fund was established in Latvia in 2013 as an absolutely new patient right defense institute with a system approach. The treatment risk fund is a good basis for the development of patient safety culture in Latvia and of learning from adverse events. It was established on the basis of the directive and the application of patients' right with the aim of allowing patient to defend their right and receive a compensation according to out-of-court procedure. This is the definition of the patient's right to receive compensation in law of Latvia. But there are several aspects that indicate the regulatory framework of the treatment risk fund fails to comply with the directive and the applications of patients' right. And this has a significant effect on the consequences due to such non-compliance. First of all, it's difficult for patients to receive compensation for harm in case when during the examination of the compensation claim no causal link is found between the harm and the action of failure to act by a medical practitioner during the medical treatment process. It's because one of the circumstances due to which a compensation is refused to patient is a case when no causal link has been found during examination of the compensation claim between the harm and the action of failure to act by a medical practitioner with the medical treatment process, by thus creating obstacles to patients to receive compensation for a harm caused by conditions announced during medical treatment. Next, it is difficult for patients to exercise their right to receive compensation in case when other person involved in the medical treatment process and the medical treatment institution have caused the harm. The delegation of functions and tasks at healthcare institutions tend to change. The directive of the applications of patients' rights include a concept of health professional, which is the meaning of the directive is a doctor of medicine, a nurse, dental practitioners, a midwife, or pharmacist, or another professional exercising activities in the healthcare sector with, which are restricted to regulated profession or person considered to be a health professional according to the legislation of the member states of treatment. And this concept is much broader than the concept of medical practitioners, including in the Latvia law on the right of patient safety and treatment risk fund. Next is not only medical practitioners particularly unprotected in the framework of their professional activities and may be called to administrative or criminal liability after the examinations of patient compensation claim, but the treatment risk fund even increases the possibility that medical practitioner can be held legally liable. According to the operational rules of the treatment risk fund, the medical documentation of patient existence or non-existence of harm and existence or non-existence of condition for a refusal of a compensation for harm is to be examined and conclusions are to be drawn by the health inspectorate. One of the tasks of the health inspectorate is also to examine administrative violation in the case stipulated in the Latvian Administrative Violation Codex and to impose administrative penalties or to hand the cases over to an investigative authority which is authorized to launch a criminal procedure when the health inspectorate finds indications for crime. And the last, the liability for the actions or failures to act by a medical practitioner employed at a medical treatment institution as a result of which harm has been caused to a patient's life or health has been directly transferred to the medical treatment institution. According to the treatment risk fund operational rules, the treatment risk fund consists of funds from medical treatment institutions obtained from medical risk contributions or recovered as a result of resource. The amount of the risk contribution is determined of the medical practitioners working in the medical treatment institutions, where the obtained funds are used to not only compensative harm caused by actions or failure to act by medical practitioner employer at the medical treatment institution, but also to compensate harm caused by conditions during medical treatment. And what should be done to change this situation? Firstly, amendments will be necessary to the law on the right of patients in accordance with the directive of the application of patients' rights, stipulating that a patient is entitled to a compensation for harm caused as a result of the provided health care. Secondly, the treatment risk fund and assessment of compensation claims should be clearly separated from the institution which is authorized and obligated to penalties medicine practitioners, and also treatment risk fund operational rules should be clearly revised, taking into account of fundamental principles of customer safety, including by researching who is the subject of insurance, the patient or the medical practitioner or the medical treatment institutions. And as such, considering the medical treatment process not only involves medical practitioners but also pharmacists and medical treatment support persons. A much difficult task will be changing the mentality in the field of patient safety culture towards a policy that is reflected in legislative acts and that fails to comply with the common principles of customer safety in Europe. Thank you.
Thank you.
Some questions from audience? Okay.
Yeah. I'd like to introduce my colleague Clayton O'Neill to deliver his paper on religious and cultural beliefs and the potential for patient safety to be compromised in the United Kingdom. Clayton's a lecturer with me in the law school in Nottingham Trent University.
Thank you very much, John, and I'm really delighted to be here, and it's great to be in this lovely city, especially walking around. I think with having such cold weather, I really get to feel the ambiance. So today I'm going to talk about religious and cultural beliefs and the potential for patient safety to be compromised. In the United Kingdom, broadly speaking, the General Medical Council, or the GMC, state that beliefs of patients may cause them to ask for a procedure for mainly religious, cultural or social reasons, and subsequently refuse treatment that a doctor might regard as being beneficial. Additionally, the National Health Service, the NHS, has produced guidelines for staff to better understand the need of patients with particular religious or cultural beliefs. The NHS state that there is a need to raise awareness of religious stereotyping, and that staff should be aware of different beliefs and practices of individuals. Notwithstanding the existence of guidelines that support this, there are, however, instances where the manifestation of religious belief might be perceived to impact negatively upon patient safety. One such instance is the refusal of blood transfusions by Jehovah's Witness patients. There are other instances, such as perhaps ritual male circumcision. So in the context of Jehovah's Witnesses who refuse blood transfusions, a number of cases have actually come before the English courts. In all of these cases, in the context of adults, notwithstanding some nuances, they have found in favour of the adult patient who has capacity to be able to act in accordance with his or her will. as long as there's been no undue influence or duress, they're basically allowed to refuse this blood transfusion because they've got the capacity to refuse it. So for an adult, the issues of consent and capacity are key factors. The situation, however, is more complicated in the context of Jehovah's Witness children. The courts have consistently refused permission for a child to refuse the blood transfusion. The courts, however, have been criticized by many for being overly paternalistic and for denying competent children the right to be able to refuse the treatment. In English law, we have a concept called gillic competence. A gillic competence means that if the adolescent has got sufficient intelligence and understanding, he or she should be able to make the medical decisions they want to. But that has actually almost become a fiction, because there's subsequent case law that's saying even if they've got this intelligence and understanding, the courts can just override their wishes anyway, which is basically what's happened in the context of Jehovah's Witness children refusing blood transfusions and other situations where we've got children making decisions that could impact upon their lives. So what has the Royal College of Surgeons said about this? Recently, they've produced guidelines in response to the really important Supreme Court case of Montgomery, where in Montgomery the concept of consent was clarified in English law, where it really endorsed a principle of informed consent and to get rid of this concept of medical paternalism. So these guidelines by the Royal College of Surgeons indicate that doctors need to take reasonable steps to make sure that patients are informed of any material risks associated with the treatment, and the patient should be told about alternative treatments, such as in this context, maybe using alternative methods other than blood transfusions. These guidelines clearly state that there is now a move away from paternalistic, traditional models of consent to one that now puts the patient first. That's what the Supreme Court say. Does it happen in practice? Perhaps that's not just as easy. But this really means that it's meant to be, following the Supreme Court case, that surgeons need to change their attitudes, and they're no longer the sole arbitrators of determining the risks that are material to their patients. The Royal College of Surgeons explain that discussion needs to focus on the individual patient. Therefore, the practitioner needs to know the patient sufficiently in order to comprehend their values and views. So what are some of the overall trends that relate to religion and culture interlinking with patient safety? I think that there's a need to empower patients to have a greater understanding of both their right to express their religious or their cultural beliefs as it applies to the medical care, and equip them with the full knowledge of the consequences of any actions or non-actions that they may take. All of this leads to a need for a greater cohesion between the medical, legal, and societal systems, where patient rights and patient safety are part of an agreed agenda. There are instances where the manifestation of religious belief does actually result in the compromising of patient safety. But patient autonomy is key. A healthcare system that only aligns patient safety with very confined medical parameters would be one that ultimately negates personal autonomy. There are generic variables associated with patient safety, but an individualistic approach is also required, where the understanding of the makeup of an individual patient can result in a better understanding of his or her healthcare needs. Within the parameters of this individualism, the religious and cultural beliefs of the patient can indeed be included. Patient safety has to extend beyond the error and harm definitions to now encompass something a little bit further reaching than that. The concentration on error and harm in the safeguarding of patients on the part of healthcare professionals fails to take into account sufficiently the role of the capacitated or perhaps the incapacitated patient in the context of his or her own medical care or medical decisions. We can look and accept in many ways the definition of the WHO, who define patient safety as prevention of error and adverse effects to patients associated with healthcare. However, it is proposed here that an understanding of patient safety be extended to prevention of errors and adverse effects to patients associated with healthcare and decisions taken by healthcare personnel and or patients. The addition of this latter statement could have meritorious consequences in tort, insofar as it provides recognition of the fact that the patient is an equal partner or even a pivotal partner in relation to the medical treatment and what he or she has consented to. The broader perspective of patient safety would offer a more holistic view of the patient that recognises patient values and belief systems. This links in with the way in which tort now puts the opinions or the consent of patients first and rejects medical paternalism in line with the Supreme Court Montgomery decision. By recognising the role that patients play in the determination of their safety and by acting upon decisions made by patients based in this case on religious or cultural beliefs, the opportunity arises for a more open and shared dialogue between healthcare professionals and patients, leading to a greater understanding of medical treatment and its consequences. This surely has the potential to lessen contention and to reduce negligence claims, and can emanate from situations where such contention exists. The broadening of this definition of patient safety comes from a philosophical base where value is given to the right of the patient to act in accordance with their beliefs. Thank you very much.
Thank you. Just in summary, very briefly, I mean, certainly in English law, when you look at ethics as well, should the patient always be able to do what they want in terms of autonomy and relative autonomy? A Jehovah's Witness say very good reasons for refusing blood, but the mother is leaving 4 children and a husband. If she's got capacity in English law, she can do that. But if we're dealing with a 16-year-old who's got, say, a child, the courts will say, well, actually, you can exercise what we call relative autonomy. We'll suspend your autonomy now and say, no, you can't end your life. And then if you're 18, then you can. So you can exercise more autonomy. There's also an issue that we've perhaps moved too far in the autonomy debate, that medical ethics is totally obsessed with autonomy. We need to look at other ethical theories as well. And often these autonomy arguments are based on faith arguments. And that's another problem, but certainly what we need to think about, I think, reflectively as medical lawyers, is this issue of really, can we do what we want? And what about the effect of our decision-making on other people? How should that be taken in the equation? Our actions affect others. So perhaps we've moved, arguably, too far down the autonomy role, and perhaps we need to think about other ethical issues as well. Any questions to my colleague here?
Thank you very much. It was really explaining the point of view. I would, just for clarification, you in your conclusions, you said the definition, which is mentioning the decisions made by healthcare professionals, should be amended with a statement that the decisions should be first of all like counted all decisions, including patient decision, and of course
patient decisions, and not just focusing on errors in relation to what healthcare professionals do. So also taking into consideration decisions that actually patients do and how that actually results in potential patient safety issues as well, not just the actions taken by doctors.
That's I fully agree, and I will also present on the same. But do you see many other suggestions to medical doctors where there is quite much stress on a decision done by healthcare provider, compared to the decision and value of the decision of the patient?
Yeah, I think there are instances where it occurs. I think that in situations where you've got patients who've got strong opinions that directly go against what the healthcare professionals want, where you've got this conflict and then they're deciding to disregard the vast majority of medical opinion, where in those instances it kind of can come into play.
Thank you.
Thank you, and thank you for your presentation. And so the next presenter should be Morgan Shimwell, but yes, because of unforeseen circumstances, Professor Tingle will present his topic, and please.
Thank you. Just today, before I came, I was checking the BBC News, and there's a new report that's saying that there are real problems with medication safety, and that there are lots of instances now where people are being harmed by defective drugs, by not taking the instructions properly, and by wrong people dispensing drugs. My colleague Morgan Shimwell has done a paper which he's looked at the issues of medicine, and also looked at these issues in terms of recent publications from the World Health Organization. And he's given some evidence to the WHO. Every few years, the WHO in Geneva have a world medical policy, and they employ lots of publications and lots of workshops in different areas. Previously, it was washing hands, safety, prevention of infection. And the years after, it was safe medication, it was safe operating theatre procedure. And in Bonn, in November of last year, the World Health Organization launched medication without harm. So this is the latest WHO international policy where they're trying to reduce error. It was launched in a global ministerial summit. If you go online, you can see the presentations there. The global cost of medication errors is $42 billion. In the US, one medication error per patient each day. 1.5 million avoidable errors each year, resulting in 7,000 deaths. Causes of medication, human factors, but also systemic failures in healthcare systems. What is a medication error? It's any preventable event that may cause or lead to inappropriate medication use or patient harm while the medication is in the control of the healthcare professional, patient, or consumer. So, who have involved quite a lot of people nationally, internationally? There is a WHO, World Health Organization, Patient Safety Collaborative Network, which I'm a member of. And if you go to the WHO website, you can sign up to join this network, and they consider your application, and then if you're accepted, you can join different working groups, and then you receive messages from them. And one of the messages was, we've launched this, what are the research questions? What should the WHO research questions be globally on medication safety? And you can contribute to that, and we contributed to that. The aim then is to reduce avoidable harm related to medication by 50% globally in the next 5 years. What we're looking at are 5 objectives: assess the scope and nature of avoidable harm, create a framework for action, develop guidance materials, technologies and tools, engage key stakeholders empower patients. And there are 4 key problem areas: patients and the public, medicines, healthcare professionals, systems and practices of medication. And Morgan's spent a lot of time thinking about this, and his PhD was in this area of medication safety and defective drugs. When we look at knowledge building and the first problem, and expertise, there is an assumption in the documentation so far that patients have a knowledge deficit, are disempowered and are waiting to be educated. That's an issue that, I mean, really do patients have a knowledge deficit? Are they disempowered? And are they waiting to be educated? Because if we look at action point 2, convene national experts, health systems and practitioners to produce guidance, but there's no recognition there of the patient. Action point 3, the use of tools and technologies to enhance patient awareness and knowledge. Well, patients, well, they said this in the Montgomery case, and those who are students amongst you, the most important English case in the last, I suppose the most important ever English medical law case is the Montgomery Supreme Court case, which is not a long case, but the philosophy in that case is really important. And you can look at it on YouTube, and if you type in Montgomery case, Supreme Court, then you'll see the judges giving the outcome of that case. But what it says, Montgomery, is that patients are not there to be mended. Patients are partners. That a few years ago, patients were the passive recipients of care, but they're not anymore. The internet, their awareness, patients are experts also in their own care. But interestingly, when we look at this issue globally, there's a failure to recognize patient expertise and a failure to appreciate complex networks of medication knowledge. So what we're doing is looking at the WHO project, and we're saying, yeah, thank you for rolling it out, really important. We want to reduce it by 50%, but also don't forget that patients are there as well, and they're an expert and they're a resource. Substandard medicines, the problems of falsified medicines, that medicines that fail to meet the quality standards, falsified medicines, and organised crime, the legal supply chain. In Uganda, you can buy anything you like from a shop. There's no real control over the medicines that you buy. You can buy anything. Antibiotics. But the more we use antibiotics, the less effective they're going to be. A lot of falsified medicines end up in Africa, and it's the patient safety sort of issue. So it's a welcome initiative, the WHO Medication Without Harm project. It shows signs of being open to input from a wide range of stakeholders. To be effective, it needs to be more inclusive and involve patients and their problems. So Morgan apologises that he wasn't able to present this. He's with us in spirit, and hopefully he'll be able to visit with us when we come back, hopefully in May. Thank you.
Thank you. And some questions from audience for Professor Tingle, because right now, let's say we move to next part of our program, and but probably one question in general from my side would be like that: how you see the collaboration between, let's say, Faculty of Law and Faculty of Medicine in your university or other UK universities? Is there any progress in this medical education to be shaped in order to prepare health professionals with, let's say, better understanding of those issues?
A few years ago, I was invited to taught to the law school at the University of Turin in Italy. And I think it was the first time in 50 years that the law school and the medical school had got together for a presentation. I don't think it happens much. Not all universities have medical schools. A lot of universities have law schools. But I think one of the challenges is to bring both professions together. And it is really difficult. Because if you think about the power relationship, who is the most powerful person in the care equation? The 25-year-old doctor or the 65-year-old professor of medical ethics? It's the 24-year-old doctor. And one of the issues is how we balance the care equation and bring these together. And we've been discussing in our visit this week lots of ways in which we can involve students, medical students and law students together to look at patient safety exercises, to do presentations, to explore common problems.
Thank you. Some more questions? Okay, go ahead. And so I will give floor to Liiva Stupele about medical error reporting system implementation, how it works in reality in Latvian hospitals.
About reality, we will see in a couple of months or years. So, I will present you today my research on the medical error reporting system implementation possibilities in 2 Latvian hospitals. This research was done before 2017, October 1st, when the Cabinet of the Ministers in the law, in the regulation, it stated that this system should be in place as an obligatory system in all healthcare facilities. So this was done before that, so I will present you the outcomes. And I'm representing the Vidzem University of Applied Sciences. Slowly, but just key factors about the background. As Professor Tingle mentioned already, 1 in 10 patients suffers from the harm receiving medical care. This is, let's say, only official information currently that we are using everywhere. There's no specific country data. There have been studies, but it's not quantified, so we can't really say what's the percentage or what's the statistics in Latvia. Also, according to WHO, around 43 million patients safety incidents occur every year. And I would say that medical errors vary in their severity and frequency, and they're present in every healthcare system, at every healthcare level, in every country. And most of the errors are system errors, and that's approved by WHO, and that's now stated that it's no individual fault and individual blame, but that's related to the system that individual works in. And based on the literature, between 50 and 80% of medical errors are systematically preventable. So that's a huge number of errors that could be prevented in the future. One of the things that got me fascinated about this medical error reporting and learning system was the passion and the experience from Evia, and that inspired me to discover and this topic more further. And as I see this is a platform and a tool where medical personnel reports errors with the aim of gathering the information, analyzing and learning from it. And as I mentioned currently, at that stage and now on, there's no national reporting system, but from 2017, October 1st, there should be a local error reporting system. So how that functions, we could see in, I don't know, in 2 years, let's see. The objective and the questions that I raised was to investigate the medical error reporting system implementation possibilities in 2 Latvian hospitals, and what are the factors affecting medical staff in medical error reporting, and in both hospitals, what are their preparedness to introduce the systematical medical error reporting system. I chose 2 hospitals as a case study. One was a regional hospital and one was local hospital. I focused my attention on intensive care units and emergency departments. Based on the studies in the literature, I find that these units were at the most risk for harm and errors because of their specific organization and type of the care that they deliver. And I did around 25 interviews with medical personnel, both in different levels, head of the departments, nurses, doctors, all involved, hospital administration, and also experts in the field. And what I concluded, what were the results? I would say they almost 100% matched with the description in the literature that the medical errors were perceived as isolated cases, which was as a fault of given individual actions or lack of actions. There was no relatedness with a systematic approach. That there's no link between this error or that happened with system weakness and processes within the organization, and that means all the attention on, maybe sometimes all the blame goes to one specific person. And with this mindset, it's sometimes it's like we'll pick this person out and then the problem will be solved till the next problem. So there's no systematic view on this. The key thing is that why people may or may not report their or their colleague errors is internal culture and historical experience, making with if the error happens, if there's no fault or no blaming, the chances that people might report are higher than the previous experience of blaming and also attitudes, not only procedural writing or explaining why this happened, but also attitudes from hospital administration and colleagues as well. Which surprised me very is that in one of the hospitals, attitude from the colleagues was very key factor why people said we will not report because my colleague comes the next day and say how you could do that, and this attitude from the colleagues. And as it was said in the literature, the hospital managers and the leadership and the understanding and from their point of view is the key factor why this will develop in a good way or not. Mentioning if the head of the board fully understands why the system needs to be in place, what's the aim of that, what are the roles for each of the stakeholders, it's more likely that system will work and they will reach the benefits out of that. If it's only procedure because we need to have procedure and it takes so much time and so much energy and it's costly, and after investigating the incident we need to make changes, and for that we need some money and we don't have money for that, so people will not report their mistakes and the system will not work as it should be. And my conclusions were that before creating even local reporting systems, there should be specific definitions about what is considered as an error, what should be reported, what should not, the line between error, negligence, and intentional harm. So that's still an issue, because in one of the mindsets that is an error, that is a mistake or a slip, and that is not, so that should be clear. Also, legislation changes are needed before implementing also national error reporting system. And I could say from my side, currently this process is slowly starting to happen, and we are moving forward with legislation changes, at least in the discussion level. Also, more awareness and education about patient safety, because when I did my research, there was when you say patient safety, people are very confused what you mean with that. Is it rights of the patient? Is the physical safety? Is the building? Or what kind of safety you're talking about? And only some of the people who I interviewed were, yes, I know what that means, or I have some idea what that could mean. So I know things are very much changing at the moment, but still it's a very lack of information and education about patient safety and the concept of that. And on my side, I would like to conclude that professional associations should be more involved and should lead this idea of patient safety and also medical error reporting system as one of the tools. Because they have this role of recertification, and they could make it possible that one part of the continuous education is related to patient safety, and that's why also make it a bit obligatory in this recertification process. Yes, those were my main conclusions, and I'm happy to answer your questions.
Just as an observation, I mean, in England, we've had for about 15 or so years what we call the NRLS, the National Reporting and Learning System. And we've actually dealt with the issue of definitions, what's reported, what's not reported. And we've also got a revised incident framework for serious injury. So one of the things you might look at, if you're looking at those definitions, is we've actually thought about that quite a lot. And it's something you could import. One of the key points that I'm really interested in is not reinventing the wheel, that if there are things out there that you can use and utilize, then it's better to do that rather than start from afresh.
Related to the definitions, I would say definitely we will not create our own definitions. We will, I think currently we are adjusting WHO approved definitions and explanations of the terms.
They may always not be the best ones. I mean, I would sort of cast your net fairly wide if it's worth it. Thank you.
Some more questions? One question from me. What do you think in the stage when we are here in Latvia, when we are just starting to implement reporting systems, and we know how it's hard to implement, and as you said, that hospitals differs from and culture differs, and so we are in beginning of this way. Do you think the concepts, new concepts about patient safety, enlarged concepts like presentations today, also the concepts of patient safety, let's say, moving to this patient rights, cultural rights, and such as broader understanding of safety? Is it okay for this moment here, because we just are on the very beginning of this way? So if we enlarge these concepts, then probably would be much harder to go further if basic things are not yet set.
Thank you for the question. I think at the moment we are trying so many different things and seeing how this might work at our situation. The one thing that is very clear to me, even despite the fact that it should be obligatory at the moment, also reporting system and around 9 other patient safety related procedures and goals in a legal framework, I would say there's so much work needs to be done also with the medical staff, but I would say a lot of with the head of the hospitals and head of the medical institutions, because the leadership and also from the association point of view, it also comes from there. We can't, like colleagues mentioned, we can't go top-down approach. We need to create this culture from inside, from the leadership point of view, in the concrete organization and also amongst the professionals. I think we should, in my perspective, we should start to raise some kind of goodwill ambassador movement towards patient safety, and not only one person as a flagsman, which I can mention is Evia, but as a movement, not separate 1 or 2 people, but as a more and more as a movement.
Thank you very much.
Thank you.
So it's Silvita, and she's going to talk about participation of patient family members in hospital care as patient rights and as also as a patient safety issue. And I think you teach both lawyers and doctors from a fairly unique perspective. And we were talking yesterday about her research interests, and she's been working very closely with a colleague of mine called Austin Garwood-Gowers on transplantation issues, and has published very widely in the area, and is certainly a very well-respected Latvian legal scholar. Thank you.
Thank you, Mr. Chair, and dear ladies and gentlemen, dear students. I'm happy to see all of you here, and I would like to present a topic which is, well, scientifically very important one, but also it is so important human-wise. We all are at risk to run in this illegal situation every day if you live in Latvia, and therefore I would like to stress the need to change present approach in hospitals towards participation of patients' family members in hospital care. And I will look in my paper whether restrictions I will demonstrate to you are in line with the Latvian patient rights law, so whether they are legal, and how they could influence patient safety in hospital. So, I'm sorry for my dear English colleagues, you will not understand, but one of the biggest hospital in Latvia has a policy published nicely on their webpage, and they are exercising this policy daily towards every patient arriving at Riga Eastern Hospital, where we are teaching our students as well, and situation is following. It is clearly stated that relatives of patients are prohibited to be next to the patient near emergency care situation when patient is arriving to the hospital. Except when the patient is child, even I don't know how legally adult hospital may have a right to admit children. This is contrary to children's rights. Or exception is if the patient has problems of intellectual character, and working in medical law so long, I would say I have a difficulty to understand what do they mean. But clearly this instruction to everyone coming into hospital and to their, as well to health practitioners working in a hospital is legally questionable. And The same situation is applied in Stradiņš Hospital, second biggest hospital in Riga and in Latvia. I had a terrible case as I'm working as attorney at law. I was invited by the client to consult him and to support him in emergency care. And I had a case when the medical professional requested me to leave my client and claims that I'm prohibited to provide lawyer services for my client, which was previously agreed with another doctor, even in writing. And there was clear patient request to do it. And as a lawyer, of course, I had to say, sorry, I don't see legal basis for your request. And then they invited the guard to track me out of the emergency room. And so this is a picture from 2014 where clearly it is said that it is totally prohibited to be next to your relative in emergency care. So I am, from personal perspective, I'm really afraid of situation when my relatives might turn into need to receive emergency care in Austrumslimnīca or in Stradiņš Hospital, because I really know how dangerous it is to put them in such situations where there is no proper care from the perspective of patient-centered care, from the patient-first perspective, and so on. I'm very happy to be in line with what Professor Tingley said, what other colleagues said, that it is obviously clear that today we believe that patient-centered care is the best way we can provide care. That paternalistic way of treating patients is old approach which is more dangerous than valuable. And I am therefore looking forward that we have to adopt a new model. We are having enough scientific data is really benefiting everyone, both patients, families, and the doctors as well. And therefore, I choose this presentation for today. I hope that something will change, because I'm happy that presentation I did last conference a year ago made slight changes to the better. So, if you look at the principles of patient rights enshrined in the WHO Declaration on Promotion of Patients' Rights, this is a European document of principles, therefore I'm referring to it. Everyone has a right to respect of his and her person as a human being. When the patient comes to the emergency, he's still a human being and he deserves respect. And if we are saying that he is not allowed, even one person, the closest person to him, to sit next to him, is that respectful to human being? I believe we are treating that patient as a chair or as a bed, as an object. We are not respecting human need. This is, in my understanding, the really indignified way to approach patients at any situation. Second principle, everyone has a right to self-determination. And I fully agree with my colleagues from UK. It's a patient who has to make decision. It's not a healthcare professional to make decisions on these matters which is directly related to patients. Doctor doesn't have anything to say how much I would like to have my husband next to me when I'm really ill. And I would still deserve my right to say whether I would like to have my husband or not. Thirdly, everyone has a right to physical and mental integrity and to the security of his or her person. And having the family member next to him, it's both physical and mental integrity issue, and it is also, of course, security issue. I need someone who is really helping me to feel safe in this terrible emergency situation. And I know very well that my husband is the right person to do it. And I am not willing to allow anyone else to take these decisions. Then, of course, it's right to privacy as well involved here. And of course, as already Clayton told, it's about moral and cultural values. We are living in our culture, and we are really relying on our next of kin. We are really relying on our closest people in the case of any terrible human issue, like disease is. And we should not allow some hospital administrators to destroy that culture. That would be wrong. Then, if we look into the WHO Declaration of Patient Rights, there is expressly written and stated that the patients have the right to be treated with dignity in relation to their diagnosis, treatment, and care, and which should be rendered with respect for their culture and values. And secondly, patients have a right to enjoy support from family, relatives, and friends during the course of care and treatment. It is recognized in principles that the family, the relatives play an important role in care. And it's nothing wrong. It's really the principle of patient rights, and one should simply implement that principle. I don't see even the point to discuss it, whether this principle is correct, because I will go further with scientific evidence. It is really correct one. If you look at from the legal perspective of Latvian law, I would say that according to Latvian law on patient rights, that Article 5, Section 7 provides that the patient may agree to the presence of other persons during medical treatment or to invite other persons, and exceptionally can be exclusion if it does not hinder the medical treatment. So what the law says, the patient is a person who is making these decisions. Therefore, like Austro-Muslimnica doesn't have legal background to make these decisions. And this is a patient who is either inviting his relative or is prohibiting. It is a patient's decision to do such a choice. But I see in practice that our medical doctors are really strongly arguing that any presence of patient's relative is hindering the medical treatment. As long as I have seen several situations, I never saw such reality of hindrance. Of course, exceptions should be applied in the case it is objectively proving necessity of such restriction, but then really we should have a case-by-case decision stating that this is exactly this situation when there is an endangering situation for patients, like a relative is coming with a flu, coughing like crazy. But we have a general prohibition to every patient in this situation, and this is contrary to the law. There is, in my opinion, good scientific evidence collected, and I would mention just one scientific institution is the Armstrong Institute in Johns Hopkins University. They have some good articles published that inviting family member to the hospital and involving the family member in the care improves patient safety as well. It makes less, it helps nursing, it helps care, it helps decision making, it helps patient himself. It brings several benefits. In its improving patient care. I have a case now in my attorney's practice when the patient's family member, after she was 18 hours in emergency care with undiagnosed stroke, the patient's relative was the first who said, sorry, you have to look, there is a signs of stroke. If that relative would be next to the patient from the first hour, she would definitely be able to notice all these signs much earlier, and that would contribute to better treatment. So there is patient safety reason, a very important reason. And there is also, of course, it's not my own idea, it is scientifically proven. Another good example is just WHO published recommendations on intrapartum care for positive childbirth experience, and they have a special chapter on companion of choice is recommended for all women throughout labor or childbirth. Another a good example where it is clearly stated that this is important medical issue which is bringing positive also medical outcome. So therefore, I don't see the point to dispute that Latvian system is much better than all these other experiences done somewhere else. And there is another, this is Johns Hopkins again. This is a special manual, family involvement menu. The hospital is really producing menu, is introducing relatives, and is informing relatives what would be the best way to participate in care. My conclusion, so the approach to limit patient rights to having family members in emergency rooms in intensive care units is violating patient rights. This is what is done in Austrum Slimnīca, this is what is done in Stradiņš Hospital. This is contrary to Latvian law. And I would really invite administrators of that institution to remove these restrictions immediately. Nothing to do. Everyone has to act according to law. And I would really say that these practices, it's not only not providing disrespect to dignity, they are leading to humiliating treatment of humans we are treating. And this is wrong to do in healthcare institutions. And this is, I don't think so, we need to expect humiliating treatment in hospital. We need to expect patient-centered treatment in as much as possible. And one more thing, it's not about money. This is exactly example, it's not about money, it's about understanding. To put one small chair next to the bed of patient is about understanding, it's not about the money. And the argument that we don't have money for that is not legally valid as well, because there is not so much money. And if you really don't have money, I could bring my own chair. But don't put restriction to me. And don't ask the guards to remove relatives from the bedside. So that's why I'm suggesting to really reconsider hospital policies and to bring in patient relatives as soon as possible. This will increase patient-centered care, it will increase patient safety, it will increase patient's experience, and all over, it will bring benefits for everyone on the team. And I really believe that we need to look for benefits, and that will, and if we can do something, that we should do it. We should not wait arguing that something is wrong with that. So this is what I would like to say for today.
Thank you. Thank you.
No.
Questions? Yes, please.
I really enjoyed that presentation. Especially with my accent, you might not understand it, but I really enjoyed that presentation, and I completely endorse everything that you're saying. I see that there's a breach of Article 5 of the Latvian law. Have any actions been taken in relation to what the hospitals are doing, or are there any complaints approach that can be taken in order to tackle this sort of violation of international human rights law and indeed the actual Latvian legislation?
As far as I know, as a lawyer now, I have one of my private case in court. As I decided to take an action in this respect. It was in another hospital, but the same case, violation of that article. So, and in that case, there is already a decision by the administrative court saying that health inspectorate, one institution who is responsible for quality of care, is not aware of this human rights issue and is not able to understand where do we operate this law and how do we operate. And also in that particular case, there is a decision of Ombudsman's office regarding the presence of, that was my daughter's case. I was, of course, as well requested to allow a small surgical intervention on my daughter without my presence. And the Ombudsman office agreed that this is a reasonable protection of rights of child, that parents should be present as long as there are not really clear, objective need for something else. So, but But to take such actions, it's difficult to do so, and I have not heard about other actions in this respect. However, I have heard that when our Minister of Health was on one broadcast interview, there was a call in from the audience, and she was asked about this Austrum hospital, whether these practices not allowing relatives in emergency rooms are supported also by the minister. And she was saying, no, the relatives should be allowed in these rooms. So she was recognizing as well that such rights there are in our law, and thanks God that she did it. But to take action, since I'm like active lawyer, really, if you take action, then you really face, like I faced, illegal actions against me. So it is really the problem for patients to do, because the hospitals are hiring these the guards, and when one big part, what I have always observed, is the guards are fighting with relatives. I believe that part of the duty what the guard is doing in hospital emergency room is to fight with relatives, because it's very natural for the relative to be interested with the next, with his closed one, what is going on. So we are paying money for guards instead of making better practice.
I think this is a very good example of how you say there still is such strong medical paternalism, and hopefully in having these sort of conversations and these presentations, it'd be great if it could make a difference. Thanks.
Thank you. So we will give the floor to Evi Palčai, and Evi is most central person in Latvia in patient safety, pioneer, I would say, and she will talk about the role of regulatory framework in reporting and learning.
Good afternoon. I'm a medical doctor, and I'm also a patient safety and quality manager, and I'm pleased to talk about reporting and learning system. And as Liva mentioned before, now we have such a mandatory requirement for hospital institutions to build this system and report and learn from the incidents. And I agree. I would like to say that I agree with the previous speaker on patients' relatives' involvement in treatment process, because patients can't prevent medical errors. Patient relatives can help prevent these errors. And medical errors happen still, and many researchers show this problem still, and it could be the main cause of death, not only in the United States, but in across the world. And the objective of the current study was to evaluate whether the legislation will enable reporting and learning system in Latvia. And we suggest not report only errors, but also safety incidents, near misses, or risk situations. And we could learn more from these small events we call as from the harm. And that's why we need a reporting system to manage our risks. Because reporting and learning is one of the main tools for clinical risk management. And in our study, we look what we have, what legal framework we have on European level, and we found a directive of the European Parliament and of the Council on application of patients' rights in cross-border healthcare. There are also a few recommendations on patient safety management, which includes also reporting and learning. And of course, there are a lot of initiatives on from WHO and OECD, and a lot of initiatives and good practices from different healthcare organizations. And if we would like, what they all say, if we would like to reach zero harm to patients, families, and to workforce, we have to strengthen organizational learning and continuous improvement, and we have to strengthen just culture principles in daily practice. Key findings and recommendations on reporting and learning systems for patient safety incidents across Europe also accent that legislative changes must be considered concerning the protection of information in the event reports from courts or police, as they are collected from different purposes. This is one of the main aspects which don't allow medical professionals to which don't allow think broadly on these events and maybe speak and learn from them. And it is very important to understand the causes of adverse event and these differences between medical error and between physician error, and investigate our organizational system when adverse event happens. And what does mean just cultural principles? And it is very important to understand also those principles and response differently when there is human error, or when we discover at-risk behavior, or there is reckless behavior or negligence. And when human error happens, for example, there should be support the person who made the error, investigation of the case and system problems. And also where we find in chain of adverse event this at-risk behavior, also we have to understand, have to investigate the reasons they choose this behavior. And of course, if we find reckless behavior, there is disciplinary actions in place. There should be disciplinary actions in place. And what is the situation in Latvia? We have two main law on the rights of patients, and law on medical treatment law, and law on patient rights. Rights of patients says that it is attending physician who is responsible for the quality and results, and healthcare institutions just should conform with the mandatory requirements. But it's not the same what patient safety principles say us, because not individual adverse event for 90% it's not individual problem but system problem, but we still stimulate this individual approach in our country, and human error or at-risk behavior is automatically addressed to violation of physician's profession, so paragraph 1 of the section 37 of the treatment law, which describe what actually is physician's profession. And several important non-compliances we found with the patient safety recommendations in the European level, and also coming from directive. And medical professionals may be called to administrative or criminal liability after an examination of information on incident received through reporting system. There is no protection of information received through reporting in Latvia. And there should be many questions answered and transformed to changes in legislation. For example, who is responsible for the quality of medical treatment? Is it individual physician or is it healthcare institution? Of course, also each individual is responsible for actions he do, but responsibility of the organization of healthcare institution is a system approach to the safety. What is violation in healthcare in Latvia? Is medical error violation? Do we see differences between human error, at-risk behavior, and negligence? In what way human error or failure to act during the treatment would violate medical treatment law or profession of a doctor? In what way human error or failure to act would be an administrative violation? And what is negligence and how to distinguish it from human error? And reporting and learning in Latvia should be strictly confidential, protected from legal disclosure, should not be subject to the freedom of information legislation. The fact that a healthcare professional has reported adverse event or was involved in adverse event or findings from investigation can't be reason for the healthcare professional liability. And learning should be strengthened with appropriate changes in legislation. And we can find good practices from the other industries, for example, from the aviation. They have strong regulations on EU level, and strong information protection, and also way how do they investigate adverse events in that business. And I think we can learn from that and change our legislation and to take experience from these businesses. And also this principle that the sole objective of safety investigations should be the prevention of future accidents and incidents without apportioning blame or liability. And also we can find tools which could help distinguish individual responsibility, accountability, or system failure. And it's actually from United Kingdom, and also my Dutch colleagues presented that tool, and it's I see that very valuable and use in our practices, and go through this deliberate harm test, in capacity test, foresight test, and substitution test, and then we will see what is really negligence and disciplinary action should be taken, and what is system failure. And also why not to support on EU level with including as mandatory subject for accreditation of education programs for medical schools. Why patient safety still is not mandatory for undergraduate education and postgraduate. And that's all. Thank you for your attention.
An excellent presentation. It seems to me that you've got a very good number of ways of redress against medical practitioners: criminal law, civil law, administrative law. We've just got one, which will be civil law. And the hospital will be vicariously liable for the doctor, so we go for the big pocket, which would be the hospital. And there'd be no criminal penalties involved unless it's really, really bad. And that would be very rare. Similarly, I think in Italian hospitals as well, negligence is criminal. But certainly in the UK, we're focused on one civil law route. And the idea of the criminal law doesn't really enter into it, nor administrative law. It would be the vicarious liability of the hospital, who would be the employer. And we wouldn't sue the doctor. We would sue the hospital. And they may pay up, and if they do pay up, they can pay up without admitting liability. So there's no fault with payment because they feel that they don't want to risk litigation. But thank you for that, and that was a really, really informative presentation. And again, a plug for the book in that we have a chapter on Latvian patient safety in our book, which we're really privileged to have from the two presenters there. Would you like to introduce the...
Yeah. And our last but not least speaker is Signe Mežinska, and she will talk about ethical aspects of registry-based medical research in Latvia, and probably I hope that Signe will talk a little bit about the problem which we face in research, also in organizational research, also including patient safety, is how available are data and how we could get those data, because in management science we say that we cannot manage if we cannot measure. So also the progress of patient safety should be measured, and so what is yours?
Thank you. As I understand, I have -5 minutes for my speech. But their audience, it might seem that this topic is different from previous topics, but I would argue that this is very close to patient safety topic, because we need a lot of research to speak about patient safety. And one type of research we can use is registry-based research. And it's clear that national population-based registries is a very valuable source of data for medical research. And we do have this data. In Latvia, we have a lot of electronic data about health, and these are population-based registries. It's real-world data or data collected outside the controlled constraints of conventional randomized clinical trials to evaluate what is happening in routine clinical practice. And we know that this data is held by a National Health Service or Center for Disease Prevention and Control, it can be used when other study designs may be unethical or difficult to use, and even more, it may be used in combination with administrative data, biobank data. So there's a huge amount of possible research studies. So the aim of this presentation and the aim of the project is to analyze smart practice examples for ethical governance of registry-based research in European countries to justify policy proposals for Latvia. Because one more thing is we lack regulations and we lack guidelines for use of this data. I applied smart practice analysis methodology for this research, and the core of smart practice analysis is focus of inventiveness required for public servants to overcome obstacles to innovation, which means that the government and lawmakers, they should serve society and aims of society to lead to innovation. To give a bit more background, I would like to show you a part of UNESCO International Bioethics Committee, a very new report on big data and health. And this report was issued last year, 2017. It speaks a lot about use of data in research, and it also emphasizes that appropriate safeguards should be implemented to protect the rights to privacy of individuals and must adhere to good governance on the use of data. As well, it says that the guiding principles for governance have to include the respect of autonomy and the right to information, voluntariness, privacy and data protection, transparency, equality and lawfulness. So there are many ethical aspects when we think about use of registry-based data. On the other hand, here are some examples. I just picked some random examples of research studies based on registry data and other types of data. And in different European countries, there is really a lot of this type of research. In Latvia, we have very small amount of this type of research. So it would be very reasonable to develop this kind of research. What are the risks, ethical risks, when we use registry-based data, especially when we combine this data with administrative data, or we combine this registry data with biobank data? We can speak about risks as loss of control on which project's data are used, or we can speak about risk as breach of confidentiality, loss of public trust to medical research, which is very, very important risk. Political and other kinds of misuse of data, as well as risk of identification of study participants. And I can give an example. It might occur when data are presented at very detailed level. If we use registry data and combine it with some other kind of data, and if it's about rare diseases or orphan diseases, and for example there are around, I don't know, 10 patients in Latvia, then there is a risk that we can identify study participants in spite of the fact that this data is anonymized or pseudonymization is used. If we speak about smart practice examples, I did a literature research, a lot of it, and in general, I would say that in my view, after analysis, I'm looking in direction of Nordic countries when we speak about regulation of this kind of research. And one smart practice example is overview by ethics committees. It's clear that before a research project is initiated, approval from an ethics committee is required in Nordic countries. And when we see at policy in Latvia, we can, and system in Latvia, we can see several problems. It's clear that we lack a legal requirement to review this type of research by ethics committee. There is no such requirement in our law. There are many gaps in ethics committee system, yeah, it applies not only to registry-based research, but also to other types of research. So we have to strengthen our ethics committee system. Training of ethics committee members to review this type of research would be necessary because we lack this training, and there is lack of guidelines or opinions from Central Medical Ethics Committee. In Nordic countries, Central Medical Ethics Committees or bioethics committees, they issue a lot of guidelines and opinions to help ethics committees and society to understand possible risks and to give possible solutions. We don't have such guidelines and opinions. Informed consent, when we look at informed consent, again, our law doesn't specify how to apply informed consent in such this type of research. But if we look at Nordic countries again, informed consent is generally not required for large-scale registry-based studies. It's assumed that the research subjects do not object to registry-based research if such research is approved by ethics committee. And agreement to contribute personal data to research is part of the informal contract between the individual and the state, given that healthcare is funded by the state. But again, to come to such approach, of course, dialogue with society and involvement of society is necessary. Then, regarding protection of confidentiality and personal integrity, there are also different practices in Nordic countries again. Most often data are distributed pseudonymized. There's a key between the identity of an individual and the data used by the researcher. For example, if registry data is combined with biobank data or administrative data, there is only key between those both of these data sets, but they allow to connect them in personal level. In exceptional cases, the government agencies responsible for collection and storage of national healthcare data will supply a researcher with identifiable data. In Denmark, there is such a policy, and we should ask whether we do need this policy. Or in Finland, researchers will receive data with full identification in those cases when the participants have consented to the study and have released their personal identity number themselves. One more practice is, and question is about a key file, the information connecting all the information together between the personal identity number and the coding number or serial number, where it's stored. And in Sweden, Finland, Norway, and Iceland, it's stored at the government agency responsible for the data matching, and it seems to be very good practice. And one more question is how long this key file can generally be kept for in different countries. Sweden says 1 to 3 years, 5 years in Finland, and thereafter reapproval by ethics committee is needed. Or in Iceland, it must be destroyed immediately upon linkage of some studies. If a study is very sensitive, then it must be destroyed at the moment. So the question is, what policy out of these examples should we apply in our case? And to move to short conclusions, but I would say these are preliminary results, and we will move further, and we will work on policy development for governing this type of research. I would say that lack of detailed policy, ethical guidelines, and legal regulations for registry-based data research limits use of these resources in Latvia. We have data, we could use it, but unfortunately we do not have regulation at this point. And the smart practice examples from Nordic countries should be applied, in my view, to enable research using population-based registries in Latvia. For example, regulation detailing the duty of governmental agencies to provide data for research purposes. Because, of course, we need this situation where governmental agencies who hold this data are willing to give this data and to help scientists to do research. There is a necessary regulation on ethics committee review, very clear regulation how we do that, what we should do before we start this study, regulation regarding pseudonymization, anonymization, informed consent, and storage of data, and regulation and guidelines to minimize the risk of identification of study participants. So we need a certain background, and in my view, we could look at Nordic countries as possible source of this smart practice. Thank you.
Thank you. I think that draws us to the end of the presentations. I do note on my schedule here that there's a poster session, so I don't know whether they're going to follow us in terms of what we're doing, or whether we've got to stay here. So, well, I've got to stay here. But thank you very much, and it's been an excellent morning. And I think as students of medicine and as students of law, I think what you've seen is academics, lawyers teaching, but also medics teaching, and some medics are both lawyers and medics. But it does shout out to me that Latvia's got an amazing potential, the University of Latvia certainly, and the universities we visited in Riga this week, to be one of the centres for global patient safety law, policy and practice. And it seems as if this goes into your curriculum, you'll be, really one of the centres. And if you offer a master's degree in patient safety law and policy, you get students from all over Europe, if not all over the world, coming to you. So I think what you've done is identified a very good area of medicine and law, and the presentations today have shown that you're really working very hard on that, and you're in a unique position in Europe to share what you're doing, not only with the rest of Europe, but also with the rest of the world. So thank you for coming. Thank you.
Paldies. Un posteri ir tur stūrī, tātad posteru sesija vēlties apskatīt.